the question of who can perform the narrative test. We've been asked, there have been a number of people inquiring about this. Seems particularly in relation to the psychology type questions. So let's just have a look at the courts have actually pronounced on this. So let's have a look at this. Firstly, let's just have a look at this concept of a medical practitioner. So both Section 17(1) capital A of the Act and Regulation 3(1) require an assessment by a medical practitioner registered as such under the Health Professions Act 56 of 1974. And if you see 3(1), we'll talk about 3 at page 103 of the booklet at the bottom, assessment of serious injury in terms of Section 17(1) capital A. 1A, a third party who wishes to claim compensation for non-pecuniary loss, that's effectively general damages, shall submit himself or herself to an assessment by a medical practitioner in accordance with these regulations. And then B as well, the medical practitioner shall assess whether the third party's injury is serious in accordance with the following method. So clearly we need a medical practitioner to do the assessment. The latter act, that's the Health Professions Act, does not per se define a medical practitioner, but save to say that it is a person registered as such under that act. However, the Health Professions Act distinguishes a medical practitioner from a health practitioner and defines the latter term, that is a health practitioner, as any person, including a student, registered with the Health Professions Council in a profession registrable under the Act. Okay, so effectively, to summarize that, if you want to know what the Act means when it talks about a medical practitioner, your first port of call is you must go to the Health Professions Act. Then, in terms of the Health Professions Act, there are 12 professions, each with its own professional board registered under the Health Professions Act. One of these is the Medical and Dental Council. Another is occupational therapy and medical orthotics or prosthetics. I see, for example, 17 LAWSA, that's the law of South Africa for the medical people. But this particular consideration, this particular aspect was considered in a number of decisions. We will look at those decisions in a moment, including, I think it was Duma's case, if I'm not mistaken. Then registration under the medical and dental profession. It has been held, yes, it was Duma. It has been held that the expression medical practitioner envisaged by Section 17(1)(a), that's of the Road Accident Fund Act, and Regulation 3(1), that's the one we've just looked at on page 103, are those practitioners that are registered under the medical and dental profession, Duma versus RAF. In consequence, and here's the important bit, the right to perform a narrative test excludes health practitioners such as occupational therapists, dietitians, oral hygienists, and so forth, who are registered under other professions. An occupational therapist, for example, will not qualify as a medical practitioner within the meaning of Regulation 3(1)(a) and may not therefore conduct a narrative test. So, in fact, the definition, the courts have defined the language quite narrowly there in respect of medical practitioner. However, that's not quite the end of the story, because although the main person performing the test and completing the form is the medical practitioner, that's not really the end of the story, because there's a question of the inclusion of supplementary reports. Now, for a variety of reasons, although medical practitioners should be able to provide adequately detailed narrative test reports in certain cases, it is found in practice that in many cases, medical practitioners do not or cannot provide adequate factual descriptions of relevant or altered circumstances of the third party. It is therefore recommended that the narrative test report provided by a medical practitioner should generally be supplemented by reports from other relevant experts, mainly to properly describe the relevant or altered circumstances of the third party. There may be other reasons for including supplementary reports, but it's really the supplementary reports really come into their own when one considers the altered circumstances of the third party. In other words, the claimant. In other words, it's not always possible, and very often it is not possible for the main practitioner signing the RAF4 to properly assess the alteration of the circumstances of the claimant, which is crucial for an assessment of the narrative test. And therefore, that main practitioner it's appropriate, and in fact, it is incumbent on that practitioner to then go and seek the additional assistance of other experts. And so when we come to the question of who qualifies to perform the narrative test, it's not quite as simple, with the greatest respect to the judges in Duma's case, not quite as simple as that, because you need to consider whether other reports could, or supplementary reports, I should say, would be admissible. Depending on the nature of the impairments and the particular circumstances of the third party, however, supplementary reports may be required of a range of practitioners, including neuropsychologists, educational psychologists, speech therapists, and/or industrial psychologists. So to summarize this point, the main author of the report must be a medical practitioner as defined in terms of Duma's case, read with the Health Professions Act, and we've been through that. However, other supplementary reports can be provided, and those experts who are providing those reports must know how to apply the principles of the narrative test, because much of what they say will influence the outcome of the main report. Okay, and now I'm just going to quickly go through, and I think this is a nice way to segue into what Dr. Edeling is going to say. I'm going to comment on this briefly, and then when he goes through his presentation, he may want to also comment on these particular aspects. But you will see that insofar as the completion of the RAF4 form is concerned, sections 1 and 2 should be compiled by the medical practitioner, as we've just seen, right? Sections 3 to 6 may be compiled by the medical practitioner, or may be compiled in the supplementary reports of the other relevant experts. Don't worry about the C below. We will deal with that in a moment, but we've already dealt with it. In which case, comments should be provided by the medical practitioner. Okay, so the medical practitioner, and I just want to make a point here, and it's quite important, not only for the narrative test, but also generally when you're dealing with writing a report, but you're relying on other experts, you must sanction the opinions of other experts where you're able to do so. In other words, within your professional purview, you must say that you accept those portions of other reports. If it's not within your professional purview, and you must be very clear as to what falls within your domain and what doesn't, you need to then make some sort of reference to deferring to those reports. It is also important, both within the narrative test and more broadly when you're dealing with expert reports, that where you rely on another person's opinion, you must say so in your report, and you must identify whose opinion you're relying on and what qualifications that person has. Either you must identify those qualifications yourself, or you must sanction, in other words, you must agree with what is put within the author of that opinion's report, and then you just confirm to the best of your knowledge that is correct. But the court needs to know where the information is coming from. So just a word of warning here on dealing with supplementary reports. You must be transparent. That's really the yardstick. Don't try and pass off the work of somebody else as your own. You will get into hot water. I dealt with a case where we cross-examined a medical practitioner who tried to do that, and their whole case fell apart. So it's actually quite easy meat for a sharp advocate or an alert advocate and attorney team. And please make sure that you do attribute and be transparent. Next bullet point, the supplementary report of a relevant expert should refer to the diagnoses of the medical practitioner in sections 1 and 2, and should deal in detail with sections 3 to 6. Now, where sections 1 and 2 of the narrative test report of the medical practitioner are not available to the other relevant experts at the time of compiling their report, bearing in mind inter alia that the scope of practice of such relevant experts precludes the formulation of medical diagnoses. The other relevant experts should refer to the injury diagnosis and outcome diagnosis. Now, Herman's going to talk to us in a moment about those two types of diagnoses. They're very important and highly relevant to the narrative test of medical practitioners as documented in other available medical records or reports. Now, finally, where available records or reports document only an injury diagnosis, but not an outcome diagnosis, the other relevant experts or experts should, on the basis of their own observations and expertise, provide a working description of the impairments equivalent to an outcome diagnosis and refer to the medical practitioner for final formulation of the outcome diagnosis. Then, and if you're not entirely sure of what injury and outcome diagnoses are, don't worry about that. We will deal with that in the next few minutes. Just be aware that that principle that you should at least have a working description of the impairments, which will be similar to an outcome diagnosis when you go through compiling going through the RAF4 form. Where sections 3 to 6 have been compiled in the supplementary report of the other relevant expert or experts, the medical practitioner should read the report of the other relevant experts and should provide further comment in line with the requirements. Now, I'm going to include my earlier remarks under provide further comment, endorse that report, delineate where your expertise starts and finishes. But it's not only that, it is also from the clinical perspective. Any further comment, and I think Herman might want to comment further on that aspect, that now gets beyond my field and into his field. But I can tell you in general, any further comment, that will have quite a broad interpretation. Okay, and now the next section that I will deal with will be the question of severe long-term mental or severe long-term behavioral disturbance or disorder. I'm going to suggest that we take another short break just while I tee Dr. Edeling up, because he's now going to address the meat and potatoes from the expert's point of view, the real practical aspect of how you should conduct a proper narrative test. Let's take 2 or 3 minutes break. I think we can start. It's just before 7. I'll put my video on again about a minute before I start, and then we'll go straight into actually conducting the narrative test. Thank you very much. I will see you shortly. All right, Herman, I think we could start.
Good evening, ladies and gentlemen, and thank you very much for inviting me to this auspicious event, Ian. I think it's really a very important issue for everybody involved in RAF claims to understand the narrative test as part of assessing serious injuries. Now, thank you, Ian, for giving that very clear background to what the narrative test is, the legislative authority that establishes it, and essentially how to do it. I would like to talk just loosely about the background rationale, the reason, the purpose, and the medical approach to the narrative test. So if I start with the Amendment Act, there are certain very important elements to me as a medical practitioner that are specified in the Act. The first is that determination of serious injury is a medical determination. That means it's not a legal determination or an administrative determination. It's a medical determination. And what that to me means is that a lawyer can't argue with a doctor about whether it's serious, except, of course, that a lawyer can argue with a doctor if the doctor failed to take certain things into account. And as Ian, as you said earlier, which is very important to understand, is that in expressing an opinion, a doctor expressing an opinion on serious injuries has to follow the normal expectation of court. In other words, that opinion must be supported by reasons, and that those reasons must be a combination of facts that are relevant, and secondly, a rational interpretation of those facts. So as much as it's a medical determination, the medical practitioner performing the determination must do so in accordance with the rational rules of court. The second thing that the Act says is that the consequences about which one is determining must arise out of the injuries. So in other words, the injuries in the accident must be the cause of the outcome. And for that purpose, the medical practitioner has to consider and investigate and express an opinion on causation. Now, this is a potentially complicated thing because, Ian, you spoke about a situation where a court said it's not for the HPCSA to determine causation. Now, I think it's important to establish what we mean by causation, because causation can apply in different circumstances, or different aspects of causation can apply. So in the sense of a motor accident, whether the driver was negligent and whether the negligence gave rise to the accident or to the injuries, that is an element of legal causation. But once having determined on legal grounds that that accident injured that person, then it is a medical determination what the injuries were that the person sustained as a result of the accident. So that is the first element of medical causation that is necessary from the doctor. And the second, and I will get into this in more detail in a moment, is that the permanent impairment or the permanent disability that has now resulted at the end of the day has resulted directly from those injuries and not from something else. So that is a further element of causation that the medical practitioner has to consider. So before I get into those details, I'd like to just share with you and just show you certain publications. What you see now on the share screen is an article published by Professor Magda Slabbert and myself in the PER, the Potchefstroom Electronic Review, and that was in 2012. And in this, we discussed the Road Accident Fund and Serious Injuries, the narrative test. So this is the first publication that we wrote. And in this, we discussed what the narrative test is, why it is necessary, and various aspects of the narrative test. Now, one of the problems that we grappled with, which led to this publication, is this. The Act stipulates that the medical practitioner must determine what has resulted from the injuries and whether they are serious. And then it stipulates, very importantly, taking the circumstances of the third party into account. Now, by specifying the concept of circumstances, the Act, in effect, defines a disability assessment as opposed to an impairment assessment. So I would like to stop a moment and just discuss the difference between impairment and disability. Impairment is something of the body's structure or function that has been lost. And in the simplest concept, which is the most concrete and easy to understand, if I've lost my left foot, then my impairment is loss of the left foot. If I have a below-knee amputation of the left leg, my impairment is the below-knee amputation. So that is a physical loss of body tissue or a portion of the body. That is an impairment. But an impairment can also be a functional loss. In other words, not a physical anatomical loss, but it can be a functional loss. So that, for example, I've had a chest injury which has damaged my lungs, and my respiratory capacity is now less than it was. That can be measured, and the impaired function of the lungs can be expressed as an impairment of lung function. It can also be called a loss of lung function. Just so, one can physically lose an eye, which is a loss of a body part. That's an impairment. Or even though retaining an eye, the eye can become blind. Then the blind eye is the impairment. And in traumatic brain injuries, the loss of mental function, cognitive, executive, and other aspects of mental function are impairments because they are an impairment of brain function or impairment of mental function or loss of brain function. So that is what an impairment is. And an impairment can be measured in a person being examined and tested in a laboratory or in a consultation room or in a hospital. You can measure the person and you can measure the impairments, the physical anatomical losses and the functional losses. But when you measure impairment, you do not take circumstances into account. And the Act, the Amendment Act, stipulates that circumstances must be taken into account. And what that means, as I said, is that it effectively becomes a disability assessment. So what is the difference of disability and impairment? The person who has lost a left foot or a below amputation of the left leg cannot walk as well as he or she could before the loss. So loss of the ability to walk, or a reduced ability to walk, or an impaired ability to walk, is a disability. So a disability means that you are less able to participate in certain life activities, whether that is your activities of daily living, whether it's your educational activities, whether it's your occupational activities, and whether it's your recreational or sporting activities. So any life activity in which you could participate before an accident, but in which you can no longer participate, or in which your capacity to participate is reduced, that is a disability. So, for example, a person with a brain injury and loss of mental acuity, cognitive and executive function can look perfectly normal, but their ability to do their work is reduced. So their impairment is loss of mental function, and their disability is inability or reduced ability to work, whether it as a bank clerk or a teacher or a gardener or whatever the case may be. Now, those are the three things that the Act essentially says: medical practitioner, taking circumstances into account, and resulting from the injuries. So the doctor must consider causation and circumstances. In order to do that, one has to understand the difference between an injury diagnosis and an outcome diagnosis. And that is part of the causation inquiry or the causation opinion that the doctor has to formulate. The injury diagnosis, for example, can be, at the accident, I had a compound fracture of my left femur. That diagnosis is made in hospital on the day of the accident. Or I lost my right ear. That's an injury diagnosis. Now, any injury can either lead to almost anything between death and full recovery. So if the person recovers fully from the injury, then the outcome diagnosis is full recovery. And you can have that. You can have a compound fracture of the left femur, which is treated so well and recovers so well that by 6 months or a year, you are 100%. You are just as functional, just as strong, just as capable, just as fit as you were before the accident. Then your outcome diagnosis is full recovery. You can also have incomplete recovery, which means you can walk, you can even run, but you have chronic pain in your left leg, or you've got degeneration in the knee or the hip joint resulting from that trauma. So then your outcome diagnosis is partially recovered fracture with chronic pain or degeneration in the knee joint, etc. So the injury diagnosis is what is injured on the day of the accident. The outcome diagnosis is at the end of the day, after maximum medical improvement or recovery has occurred and the condition has stabilized. Are you now restored to full health, or is anything else still wrong? And the outcome diagnosis describes what is still wrong after maximum medical improvement. If the doctor determines, medical assessment determines the injury diagnosis, which came from the accident, and then the outcome diagnosis, and then there has to be an inquiry whether every element of the outcome diagnosis comes directly from the injury diagnosis, or did something else intervene? So, for example, did the person subsequently have another injury that could have contributed to what you are now seeing 2 years later? Or did the person develop a carcinoma that had nothing to do with the accident, but is now affecting the function of the person 2 years later? Or did the person develop diabetes or hypertension or cardiac failure, which has nothing to do with the accident? So the medical inquiry between the injury diagnosis and the outcome diagnosis is, to what extent was the outcome diagnosis or permanent impairment caused directly by those injuries, or what portion, if any of it, was caused by other causes not related to the accident? Now, in this article that Professor Slabbert and I wrote in 2012, we discussed these aspects. In other words, what the Act says, what the Act requires, and then we discussed the regulations, as Ian said earlier, which were published by the Minister of Transport in terms of this Act. Now, the Act specified that the Minister of Transport had to specify a method of determining serious injury. Unfortunately, that job was done in a manner that was not very clear. So the first method prescribed in that regulation was to use the AMA guides. Now, there are serious problems with using the AMA guides for this purpose. The first and most obvious of which is that the AMA guides are an assessment of permanent impairment. They are not, by their own definition, an assessment of disability. And by their own definition, they do not take circumstances into account. They are purely an impairment rating. Now, for many kinds of impairments, they are a very good, scientifically accurate, medically accurate, and very widely accepted impairment rating. So the AMA guides are good for what they do and what they purport to be. In other words, an impairment rating. But they cannot provide the requirement of the Amendment Act to take circumstances into account. And it is for that fundamental reason that the minister's regulations had to provide an alternative method to the AMA guides in order to take impairment into account. And that is really where the narrative test comes from, because the narrative test allows one to take circumstances into account, and by virtue of that, to expand the impairment assessment into a disability assessment. Now, after this publication that Professor Slobert and I wrote, I was involved in the appeal tribunals of the HPCSA for some time. And it became abundantly apparent to all the members of the appeal tribunal that the wording of the narrative test was a major problem. I just want to show you, I'm sure you all are aware and use this document. So what I'm showing now on the share screen is the Road Accident Fund RAF4 Serious Injury Assessment Report. And this is what the doctor has to fill in for the RAF4 assessment. I'm just going to go straight to the narrative test portion of this document. It's a very small portion on this form. There it is, paragraph 5. So serious injury, the narrative test. And Ian has already said, but I just want to show it to you on this form. These words here in paragraphs 5.1 to 5.4 are exactly verbatim the words contained in the regulations pursuant to the RAF Amendment Act. And I just want to draw your attention to problems with this wording. So let's start with the first one, serious long-term impairment or loss of a body function. The trouble is that is completely vague and non-specific, and it gives no direction into what makes an injury serious. Because, bearing in mind, the purpose of the narrative test is to determine whether the injuries are serious. That is what the Act says. The injuries must be serious. And this paragraph says the injuries are serious if the long-term impairment is serious, or the injuries are serious if the long-term loss of body function is serious. So that is a circular description. It doesn't help the doctor or the lawyer or the road accident fund to understand what requirements are there for it to be regarded as serious. So this doesn't take the wording of the Act any further to say when is an injury serious. The second paragraph there, permanent serious disfigurement, has got exactly the same problem. So if there's disfigurement, it might be serious, but it's only serious if its disfigurement is serious. So again, that's a circular description. It means nothing. It's using the outcome word to define the input. The third one, which Ian was referring to, uses a different word, severe. So severe long-term mental or severe long-term behavioral disturbance or disorder. Okay, so at least that is a different word. But how does a medical practitioner decide whether a mental disturbance or a mental disorder is severe or moderate? And one would have expected the regulations to provide that clarity. What circumstances or what criteria would render the mental or behavioral disturbance or disorder severe or moderate. Because without that, it's a completely subjective assessment. So one doctor's moderate might be another doctor's severe, might be another doctor's mild, without any clarification. The only one of these which is clear is loss of a fetus. So that at least is something that is meaningful. But for reasons I've said, 5.1, 5.2, and 5.3 are so vague as to be virtually devoid of meaning. Now, this was the problem that we were faced with in the HPCSA appeal tribunals when this started happening in 2010, 2011, 2012, etc. And what we found was not surprising, because a lot of medical practitioners wrote RAF4 reports and wrote narrative test reports, but they were all different. There was no order to them. There was nothing. There was no objectivity. They were all subjective, and they just didn't help. And it's not surprising that medical practitioners could not understand how to interpret those vague words. And that was the reason that the chairpersons of the HPCSA appeal tribunals at that stage, together with myself and Dr. Rosman, who's a neurologist, we got together, and with the authority of the HPCSA, we developed a committee to determine how to actually do a narrative test and what criteria should be applied. And this is the publication that then was the fruit of that committee's work. So this is a guideline published in the South African Medical Journal, SAMJ, and it was published in October 2013. And the title of this is HPCSA Serious Injury Narrative Test Guideline. Now, in this guideline, our purpose was to remedy all of the lack of clarity in the regulations. So we dealt with who must complete a narrative test report, how medical practitioners and other experts should collaborate for reasons, as Ian has referred to earlier, what the content of a narrative test report should be, in other words, what aspects should be investigated and reported on, and finally, what the bottom line criterion is for considering injuries as serious. So I'd just like to go to that first. We found that for whatever reason, the appeal tribunals at that time found that there was a great consensus amongst all members of the appeal tribunals. If we used the words significant life-changing sequelae as the objective determining factor for seriousness of injury. So that bottom line criteria, significant life-changing sequelae, which is specified here in paragraph 2.5 on the last page of the article. It says that appeal tribunals regard injuries as serious when it's evident that the injuries have resulted in significant life-changing sequelae. So sequelae means problems that have been caused by the injuries sustained in the accident. So that's why the causation along the whole timeline and string is important. Life-changing, has the person's life changed or not? So if, for example, with a whiplash injury, you still do all the things that you did, but your neck is sore on 2 days a week, that is not life-changing sequelae. So the real determinant, apart from the causation or the sequelae aspect, is that it must have changed the person's life. And then that change in the life of the person must be significant. Now, it is so that the word significant can be interpreted differently by different people, and what you think is significant, somebody else may think is insignificant. But we tested this, and we found that there was a really very good degree of consensus in assessing various particular people's outcome and injuries, that the panel discussing all of these aspects almost always had consensus on whether it was significant or not. So that is the best we were able to come up with, to say that if the consequences of the injuries have changed the person's life, and if that change is significant, that qualifies for serious injuries. Now, how to get to this determination, whether the life has changed and whether it is a result of the accident, of the injuries. So there are 6 divisions of this test. The first is the injury diagnosis. And we've discussed that already. That is, what parts of the body were injured and what is the diagnosis or the description of injuries that were caused by the accident. Secondly, and that is a pure medical determination. Secondly, the outcome diagnosis. That is the diagnosis of a chronic condition that has arisen from the injuries. And then it is also necessary for the medical assessment to determine the nexus. In other words, in relation to the nexus between the injury diagnosis and the outcome diagnosis. So here are examples of outcome diagnoses: post-fracture syndrome with malunion and deformity, post-traumatic organic brain syndrome, intermittent mechanical back pain, and post-traumatic stress disorder. But it is essential for the medical practitioner to determine that this outcome diagnosis is or is not, or is in part, a direct result of those injuries. And without those 2 determinations, injury diagnosis and outcome diagnosis, one cannot go forward. So those are the 2 fundamental requirements. Then, because of the fact that the Act specifies taking circumstances into account, this explains how to take circumstances into account. And in this, we differentiated between 2 kinds of circumstances. The one we called external circumstances of the person's life, and the other we called individual circumstances of the person's life. Now, the external circumstances are the country and the town in which you live, the family in which you live, your cultural affiliations, your religious affiliations, access to healthcare. Those are all things which exist outside of you. It is the context in which the injured person finds himself or herself. Those external circumstances usually remain the same after an accident, so they are usually not changed by the injuries, although in certain circumstances they are changed. So if the person's consequences of the injuries required the family to move to a different town with better access to healthcare, that could be a change of external circumstances necessitated by the injuries, and which is therefore part of the outcome of the injuries. Then the individual circumstances deals with what that person himself or herself actually does. So that includes their ability to perform basic and advanced activities of daily living, their personal amenities such as sporting, other recreational activities, their life roles such as parent, child, sibling, spouse, etc., their independence or any degree of dependency, their educational status and capacity, and employment status and capacity. So those individual circumstances are the aspects of a person's life that are most often affected or changed by the consequences of injuries. So it is necessary to report and consider both the external circumstances and the individual circumstances. Now, I'd like to come to a very important point that Ian was talking about, and that is, even though the Act and the regulations, and by the way, the AMA guides, all say that this is limited to a medical assessment by medical practitioners who are registered under the medical board. That's all very well. Those are the legal requirements. But in practice, other experts, such as psychologists and occupational therapists, are often better experienced at investigating circumstances of a person's life, both external and individual circumstances. And that is why, as medical practitioners that we were, these are the authors of this guideline. They were all members of the HPCSA appeal tribunals. We recognized that in spite of the legal requirements for a medical practitioner to do it, in many circumstances, in many cases, certain parts of the assessment could be done better by other people who are not medical practitioners. And that is why we have written, if you want to read this article, you will find for each of these a detailed description of how other healthcare practitioners can and preferably should contribute to a narrative test report and the relationship between them and the medical practitioner. So the RAF4 report has to be filled in and signed by the medical practitioner. But in most cases, the medical practitioner should have regard to an occupational therapy report, a clinical psychology report, industrial psychology report, a neuropsychology report, educational psychology, physiotherapy, speech therapy, and then should annex those reports and should say here that these conclusions are influenced and incorporate the findings of this and this and this, and see those reports annexed. So we regard it as important for medical practitioners to acknowledge their limitations and to make use of experts who know certain things better than they do. So, having dealt with the injury diagnosis, the outcome diagnosis, external circumstances, and individual circumstances, the next very important element of a narrative test assessment is this section 5, which deals with chronic pain, subjective suffering, and or loss of enjoyment of life. So why is that important? And the reason it's important is that the whole purpose of the RAF4 serious injury assessment is to determine whether somebody qualifies for general damages compensation. And the lawyers here will rapidly correct me if I'm wrong, but I've grown up in the medico-legal field to understand that the purpose of general damages, which are also called non-pecuniary damages, are compensation for the intangible and aspects which are difficult or impossible to count in monetary terms. And those are pain, suffering, loss of amenities, and loss of enjoyment of life. So those elements of general damage compensation, pain, let's start with pain, has got a major problem in terms of medico-legal assessment because, number one, it's subjective. Now, everything in the AMA guides, the impairment rating, relies on objective assessment. And because nobody can photograph your pain or measure it on a scale or apply any electrical device to you to determine how much pain you have, pain is a subjective experience of a human being. And as much as you can't determine it objectively, it is a very real problem. One of the problems associated with pain is that because it is subjective, it is also open to abuse. So, for example, people who don't want to work because they've hurt their back can exaggerate the extent of pain that they have. And it's difficult for a doctor or an assessor to determine how much pain they really have. So the assessment of pain is fraught with difficulty. But the fact that it's fraught with difficulty doesn't remove the importance of pain as a long-term consequence of injuries, particularly in that the purpose of general damages is to compensate for chronic pain. Now, there's another element of pain that is a problem, other than it being subjective, in that it is abstract. So what do I mean by abstract? That is as opposed to concrete. If you've got a below knee amputation of the left leg, or you've got malunion of a femur fracture, which you can see on an X-ray, that is objectively determinable, and it is concretely measurable. Pain is both subjective and abstract. There are other impairments that are subjective and abstract. And that is, and I'm glad that Trevor Reynolds is going to be talking about that, those are the psychological consequences of injuries. Because you can't photograph or weigh or measure or detect another person's emotional suffering. The only way to determine it is to talk to the person. And luckily, there are psychiatrists and there are psychologists who know how to do that. But it's very difficult because determination of emotional consequences of injuries is also to determine something abstract and something subjective. Certain elements of emotional disturbance can be concrete or observable. In other words, if a person is very anxious, the observer can see that they look anxious. So that element of it is objective. But how they feel is subjective, only they can say how they feel. When a person is depressed, the observer or the examiner can see that they look depressed. But only the person can say subjectively how they feel depressed or what it feels like to be depressed. So there's a major problem with the most important elements of general damages compensation, which deals with pain, suffering, loss of amenities, loss of enjoyment of life. Now, the loss of amenities is at least more objectively and concretely determinable. Like you always enjoyed playing rugby, now that you haven't got a foot, you can't play rugby. So that's a loss of amenities. That is objectively determinable. But there are other amenities which fall into the abstract or subjective field. But pain, suffering, loss of enjoyment of life all share the element of being both subjective and abstract. Now, the AMA Guides has got a very, very limited and poor capacity to measure subjective and or abstract impairments. The Guides recognizes that those impairments exist, and it makes certain attempts to measure them or to award percentage points to them. But I know the AMA Guides very well. I also know Professor Ranavaya very well, who come to South Africa often to train South African doctors on the use of the guides. And it is apparent in the text of the guides, and it's apparent in talking to Professor Ranavaya, that the AMA Guides does not have a scientific method of measuring abstract or subjective impairments. And it's not because there's anything wrong with the AMA Guides. It is because there is no scientific way to apply a percentage impairment rating to something that is subjective and that is abstract. Now, that brings about another very important reason for applying the narrative test. You will recall that the fundamental reason was because the AMA Guides cannot take circumstances into account. So the narrative test exists in order to take circumstances into account. But it is also essential in the narrative test to take into account the subjective and abstract impairments. And notwithstanding the fact that that is difficult and that it is subjective and abstract, it is very real and it is very disabling. So doctors, and in almost all cases, preferably supported by experts such as psychologists and therapists, should do their best, and this is a short description of how they should do it, to determine the veracity and the significance of the pain, subjective suffering, and loss of enjoyment of life. So that is the most difficult element of the narrative test. It is also the one that is most open to fabrication and exaggeration, and that is maybe one of the reasons why appeal tribunals have to exist, in order to evaluate not on a percentage basis, but on the basis of looking at context, symptoms, congruence, coherence, and rationality, whether this person suffers significant pain, suffering, or loss of enjoyment. Okay, now those are the 5 elements of the loss: the injury diagnosis, outcome diagnosis, external circumstances, personal circumstances, and the abstract and subjective impairments. Then it is necessary to sit down and look at all of those things and consider the level or degree of changes. Now, the only way to describe those in terms of quantitative assessment is by semi-quantitative words, such as insignificant, trivial, inconsequential. In other words, if a doctor says that I think these problems are inconsequential or trivial, obviously it's not going to amount to a serious injury. Or I think they're moderate or severe or intrusive, overwhelming, devastating, or significant. So those are all subjective words, but they give some medical assessment to how bad the changes are. And then, having applied your mind to that, the final determination is now, have the injuries resulted in life-changing sequelae? And if so, are those changes significant? So that is the end of the recommendation or guideline for the narrative test. Now, this article was published in the Medical Journal of South Africa in October 2013. To the best of my knowledge, and I'm happy to be corrected if I'm wrong, there is no other competing article, publication, or law or regulation. And because this has been in existence now for more than 11 years, and because this has been used over and over by medical practitioners and has been used in courts and ratified, this becomes de facto what the minister should have done in promulgating the regulations under the Amendment Act. Now, before I hand over to Ian, I just want to show you one other thing. And that is a follow-up article that, Ian, do you see on share screen serious injury claims?
No, I don't have one.
Right, let me just put it there. Okay. So remember, our first article on the narrative test was published in 2012. This SAMJ article in 2013. Then in 2016, again, Professor Slobbert and myself wrote a follow-up article called Serious Injury Claims Rejected by the Road Accident Fund, the Appeal Process. Now, in this, we examined the whole way that the administration of the appeal tribunals was done, etc. And I'm not going to go into any of that, but just to point out that this was published in the journal Obiter in 2016. And you will see the final conclusion of this article of Professor Slobbert and myself was this. We made an appeal in this article to the Minister of Transport to say the process of determining the seriousness of an injury could be easier if the Minister were to amend the regulations so as to define the narrative test in a manner that clearly communicates its purpose, as argued on his behalf in the case of Law Society South Africa versus Minister of Transport. This may be achieved, for example, by a wording such as a narrative test report, which is intended to act as a safety net by taking the circumstances of the third party properly into account, should be included as the final element of the 3-part collective assessment process. So those were Professor Slobbert and my recommended wording to the Minister of Transport. And our further recommendation was that the process would be further facilitated if the minister were to prescribe adherence to the existing guidelines drawn up by the HPC Appeal Tribunal's task team. So by that time, those guidelines had been in existence for 3 years. There had been no challenge to them, but they did not have the effect or the authority of a regulation. And we said to the minister, these guidelines make sense. You can make the process easier if you include this or authorize this in a regulation. Anyway, that has not been done, and that is part of the reason for thinkers like Ian Dutton to do all of this work and teaching and writing to help people understand how to do the narrative test and what it's all about. So thank you, Ian. I'll stop there.
Herman, thank you very much. Very, very good. Just a couple of points that I would like to endorse, but what I'm going to do is when I deal with the psychological aspect, I'll touch on a couple of points that you've raised. But we just had 2 questions here from Elzette Leroux, and I think they're excellent questions, Herman, because they are nice little case studies, a very short, sharp little case study to give us a practical indication of what it is that you're saying. So I'm sure everybody listened with great interest. I just want to, before I let you answer those questions, I just want to make a note that all of the articles that you're referring to now, just watch on the WhatsApp group. We will give you the relevant links to the website. Those articles will all appear on the website, and people can go through them at their leisure. But Herman, if we look at firstly, the first question which Elzette asks is the following: does loss of one eye or loss of sight in one eye constitute a disability? If I follow the reasoning, the vision is impaired, though not completely.
Okay, so the loss of vision, whether it's partial or complete, is an impairment. It's not a disability. But if you use your eyes to navigate around the house when you get dressed, and now because of your loss of vision, you can't get dressed on your own, then that is it. Your disability is a loss of ability to get dressed. If you need your eyes to read, to do your work, and now you can't do that properly, your disability is loss of the ability to do your work or a reduced ability to do your work.
Yes,
so every impairment does have a consequence in a certain disability, because the impairment hampers your ability to do certain things.
Thanks, Herman. I think that's very clear. And then the second question from Elzette, and it's come up at a perfect time because we've actually got Trevor Reynolds with us now. Trevor, and we can bring you in. Herman, you can contribute as well. But the second question, she makes this really, I suppose, it's a question, but it's in the form of a comment. She says, should not all patients be deferred to clinical psychologists to determine psychological consequences or loss of enjoyment of life through testing? Trevor, I think we just give us a quick little introduction as to who you are and your background, and then maybe you want to kick off with that, and then if Herman wants to add, then he's welcome to do so. Hi, Trevor.
Yeah, hi, and evening, everyone. Thank you very much, and thanks for inviting me to be here. The obvious answer to the question before I go any further is yes, of course. Everybody should see a clinical psychologist for assessment, but I will motivate that now. I'm a clinical and neuropsychologist. I've been involved in medical legal practice for longer than I would care to remember. Being part of this discussion this evening, just having a look at who is here and seeing Herman and hearing Herman present, this takes me back to a previous life where I was very, very involved in this, and it's absolutely wonderful to be part of it again. Thank you. I think that the really important point has been touched on, and Herman has also touched on it in his recommendation, in Hiermachter's recommendation. And that is, for me, the most important statement in the RAF Amendment Act of 2008. And that is that the third party should be assessed in his or her particular circumstances. And those particular circumstances entail not only social circumstances, not only physical circumstances, not only employment circumstances, but entail life and living, quality of life. And it is unfortunately the case that very often the psychological, the emotional impact of not only injuries, whether they be physical injuries or psychological lesions, those are very often put on the back burner compared to the other things that are happening. So very often the focus is on loss of income, diminished residual earning capacity, future medical expenses, all the things that can be relatively easily quantified. But the things that are far more difficult to quantify, I think, tend to be moved a bit backwards. And this is something that I feel very strongly about, and I can talk ad nauseum about. But I think the difficulty is in terms of being able to quantify with the same degree of medical certainty or medical probability the impact of psychological harm, psychological injury, psychological lesions. That is not possible. That can't be done. The same as you can quantify the loss of a distal phalanx on the fifth digit of the non-dominant hand qualifies for 1% impairment or whatever. A very mechanistic approach which disregards the particular circumstances of the third party. So, as I said, somewhat blasé, tongue-in-cheek, yes, of course, everybody who is injured should be seen by a clinical psychologist. That clinical psychologist, I also believe, should pay particular attention to how the person's life is impacted by the losses associated with the injury, the accident, and all those points. That doesn't mean that everybody suffers a psychological injury. Not everybody suffers psychological harm, but it's an injustice to assume that people do not have psychological sequelae because the focus is on other things.
Yes, Trevor, thank you very much. There's just one point that I'd like to expand on there, and I think to really to underline. And I'm going to just, for those that have the guidebook with them, they'll find that at the bottom of page 81, if they want to follow this, it's the point that you highlighted, Trevor. I'm just going to take them through the exact language of the Act 17, and now this is 1 capital A. So now this is the section that was introduced in 2008, and which introduces the serious injury idea into the Act, concept into the Act, that's a better word. 1A, 1 capital A, small a. Assessment of a serious injury shall be based on a prescribed method adopted after consultation with medical service providers and shall be reasonable in ensuring that, and here's the crucial bit, injuries are assessed in relation to the circumstances of the third party. And that now relates both to what you said, Trevor, and to what Herman was taking us through with regards to injury and outcome diagnoses. I just want to check, thank you for that, Trevor, very helpful. Herman, anything that you want to add there?
Yes, thank you very much, Ian. And hi, Trevor, very nice to see you after so many years. And nice to hear you talking sense as in the past. Ian, the question was, should it not be compulsory for everybody to be seen by a psychologist for determination of loss of enjoyment of life?
Yes.
My answer to that is yes, it should be. The problem is that it isn't. In other words, the law does not require that. The law specifies medical practitioners. As a medical practitioner, I know that psychologists are better at assessing that than are medical practitioners. So my advice to medical practitioners is understand your limitations, no matter how good or experienced or clever you are. Whatever you write about that, just add, I defer to the further opinion of a clinical psychologist or a neuropsychologist or whatever, because you know that they understand it better. They've got better experience than you. And my recommendation to lawyers,
yes,
because lawyers are not limited in who they can appoint as experts is appoint a clinical psychologist. And if you have to get an RAF4 report from a medical practitioner, instruct the medical practitioner to incorporate and refer to the report of the psychologist. So even though the Act and the regulations don't require it, the legal practitioner can provide it and use it in that way.
Yes, Herman, that was exactly the point that I was going to make, and I think that LZ raises this. So it's absolutely spot on issue to raise, because to particularly the attorneys, but to experts as well, be aware of this psychological fallout, and be aware of the possibilities of that psychological fallout pushing this particular claimant in over the boundary with a narrative test, and then you're into your general damages. So yes, I think that's certainly something that should not be lost sight of as a quick guide. All right, we are also very honored to have with us, and I've mentioned this, Professor Magda Slabbert. Magda, I know you've been watching. Your name's been mentioned more than once. I'd just like to, at this point, welcome you, Professor Slabbert. Magda, welcome, and like to congratulate you on your work, you and Herman, and just to reiterate something that Herman made a point, but from the lawyer's perspective, from the advocate's perspective, there are numerous judgments now which have referred to the work of both yourself and to Herman, and your work has received the imprimatur of the courts on several occasions. And Herman is quite right to make the point that the de facto, they are certainly from a legal, you will know, Professor, from a legal source point of view, once the courts pronounce on that work positively, it becomes part of the judgment, and it then gets the approval of the judges. So that's happened on many occasions. So congratulations on that. But I'm wondering what you would like to add to the discussion.
Thank you so much, Ian, and hi, Herman and Trevor. Long time no see. We were, more than 10 years ago. So I want to be on a lighter note, just say that I joined the South African Medical Legal Society, and I met Herman, and Herman opened a whole new world for me on road accident funds, not from a legal point of view, but from a medical point of view. So we decided to write the first article. So Herman came through on a Saturday to my office at UNISA, and he just poured out knowledge. And knowledge and knowledge and knowledge. And as I said, 10 years younger, I was more aggressive than I am now. And I said, Herman, stop. You can't just say that. Why do you say that? Where do you get that information? So we sat with the Act and with the regulations and the AMA guides, and he took me through it step by step by step, because you can't write about something if you don't understand it. So I said to Herman, go slower. And this is a message that I can give to all of you. Make sure you understand, because if you don't understand, then you're going to miss something. So Herman took me through, we sat there the whole Saturday, and he took me through it. I also did the training in the AMA guides. But the more you understand it, and you can put it in your own words, the better it will be. But I also want to thank you, Ian, because on that Saturday when Herman and I wrote the article and the subsequent article, and it was published, and of course you feel good. But then nothing happened. And that is now where you come in. This, for me, is like a dream come true, because the academic just sit and read and write and rewrite, and you never know what is happening. There's libraries full of research, and no one ever takes notice of it. So this is extremely, extremely great. I just want to add that Obiter, the journal that Herman referred to, is not open access. So yes, you will distribute the article. I've written also one on a case discussion on Duma, also published in Obiter. I will also let you have that. So yes, it's nice seeing you, Herman and Trevor. I just quickly, forgive me for being an academic. The question of LZ on the loss of the eye. I don't know, Albert, whether you are a lawyer or a medical person, but please go and see the case of the Jager versus Netcare. The Jager versus Netcare, and then he changed to Netcare versus the Jager, etc., because they Netcare employed a private investigator to go and see whether there was actually an effect on Mr. De Jager's life after he lost an eye. And then a whole dispute arose whether it was a violation of his privacy or not. But the investigating officers eventually proved that he had no loss of amenities of life. He even drove at sunset where the sight was bad. He drove at high speed. So there was no impairment. He walked with his grandchildren in shopping centers. So he had a full life. But that was according to the private investigator's report that went and see whether he was impaired or not. Okay, and then the question arose according to Poppy, whether that was allowable in as evidence, etc. But very, very, very interesting case to just go and look whether a person is impaired by losing an eye or not. Thank you, Ian.
Thank you so
I've
much.
been brief. You asked me to be brief. Thank you
No,
so much.
wonderful. Fantastic. 2 points. Firstly, really want to underline that there is really fantastic advice regarding internalizing, understanding what you're reading. I just want to go back to a point that I made earlier. For everybody, just don't be intimidated. If you're a medical practitioner, do not be intimidated by the fact that it's an act and its regulations. You know, a webinar like this can lead you into that point with the language, but read the language, and I really want to endorse what Magda is saying. Try to understand what the meaning is. I know there are all sorts of complicated interpretation, but try and apply it to your life and your practice. That's number one. Number two, I am going to put up now a link to the Jager's case, which is going up now on Safely, and you can, for the lawyers, or maybe LZ wants to go and have a look at that case, but there is a link up in the chat box for anybody who's interested. Thank you so much, Magda. Congratulations.
Thank you.
And thank you for encouraging us. We reciprocate also for us to get the approval of a senior academic and the senior practitioners really is very encouraging to us and just gives us more motivation to try even harder. So thank you very much. Thanks, Magda.
Thank you.
Okay, perfect. All right, I am now going to just resume my presentation. I'm going to move into a topic which over the last 2 weeks or so, as we've started advertising and talking around this webinar, because there's been quite a bit of background work, as you can probably start picking up, that goes into this webinar. It's not a simple thing to put together. The law and the issues are complicated, and we need to bring together different professions. But there's one aspect that really started coming through as a particular problem child, and that is this question of severe long-term mental or severe long-term behavioral disturbance or disorder. And locked up within that language are a number of significant challenges, both to lawyers and to healthcare practitioners. So let's just have a look at that. And I'm actually going to take you through in some detail some of the issues around that, some of the legal issues, and then we will get on to when we'll bring Trevor in, and Trevor can then help us to unlock a practical approach. And Trevor will talk to us a little bit about the challenges that psychologists in particular face in this domain, but other practitioners as well. But in order to properly unpack that, it is important that we understand what's going on in the law to a certain extent in order to be able to start giving you answers to practical issues. Now, the first thing to say is that this narrative test is, as I say, something of a, and I'm sorry to say this, but it is something of a Frankenstein's monster from the jurisprudential perspective. In other words, from the legal purist's point of view, the narrative test is problematic. Now, I'll expand on that in a moment. But I first want to tell you that I mentioned to Herman the other night that my father's a mechanical engineer. And a few years ago, I had an old Land Rover and I was looking to replace it. And there was a Land Rover where somebody had taken the Land Rover engine out and had put in a bigger engine, which was a Chevy engine. And this was in the smalls column of the newspaper. And this was put forward as some great feature because now this engine was more powerful. And I pointed this out to my father, and my father was horrified. And as an engineer, he said the problem is that by putting in that big engine into a system which is designed for a less powerful engine, you are putting strain on different components of that system. In other words, you're now corrupting that system. So, for instance, the differential isn't designed to turn as fast as it does or as hard as it does. Your brakes aren't designed to deal with a vehicle that travels at that sort of pace, and so on and so on. And you've had engineers look at that system and design it. Now you've imported this strange engine, and it causes unexpected problems systemically down the line. And I've often thought of that analogy, and I'm sorry to say the narrative test falls into that type of category, because the narrative test was pretty much imported from an Australian test, which they devised and which sprung out of the Australian system, and in fact is not something that is homegrown on South African soil in accordance with the South African legal tradition and legal principles. And it is my view that it's this odd test that has just been dropped into the structure of the regulations that gives rise to all the practical problems that many of the practical problems that we've been discussing tonight. So with that slightly unhappy background, let's see if we can start making some sense of this particular sub-regulation. And in particular, I'm talking about Regulation 3.1b, Roman 3c. And so that is the regulation which you will find, for those with the guidebook, you will find at page 105. You see it about 2/3 of the way down the page. But this is now importantly part of the narrative test. In other words, you've now been through your assessment as to whether the injury is excluded in terms of the non-serious injuries. That's in terms of Roman 1. And you've been through Roman 2, which is the AMA guides. And now we get on to 3. An injury which does not result in 30% or more impairment of the whole person, so WPI test, may only be assessed as serious if that injury, CC, resulted in severe long-term mental or severe long-term behavioral disturbance or disorder. And there we have it there. So the real crux here, severe long-term mental or severe long-term behavioral disturbance or disorder, what does that mean? Firstly, I just want to take you through this concept of emotional shock, which also finds its way into RAF legislation, albeit through the mechanism of Section 19 of the RAF Act. And in fact, Section 19 excludes emotional shock. And Section 19 deals with a number of circumstances in terms of which liability for the Road Accident Fund is excluded. One of those is that the fund or an agent shall not be obliged to compensate any person in terms of Section 17 for any loss or damage. And then we get on to suffered as a result of an emotional shock sustained by that person when that person witnessed or observed or was informed of the bodily injury or the death of another person as a result of the driving of a motor vehicle. So the important point here is you must just be careful that this concept of emotional shock is not the same as the concept dealt with in the narrative test. And we will look at that in a bit more detail, but you can already see why not, because the concept of emotional shock is specifically limited to circumstances where some sort of horrific event was witnessed by the claimant. In other words, they saw something happen to someone else. It's not something that happened to them. And so that's a different concept, and that concept, as we can see from Section 17, is completely ruled out of a claim in terms of the Road Accident Fund Act. The legal concept of emotional shock relates to an individual making a claim for psychiatric injury caused by witnessing the death or other horrifying event of a close relative. We normally say close relative, or possibly another person. We don't have to worry about that particular possibility for tonight's purposes. I'll just mention briefly, it's one of the ways that the court doesn't allow this type of claim just to become unlimited. And I will get back to that in a minute or two, as a result of earlier clinical negligence. All right, so just recap that. The legal concept of emotional shock relates to a person making a claim for psychiatric injury caused by witnessing the death or other horrifying event of usually a close relative as a result of the, and it says clinical negligence. In fact, that should in this case be, it would be if it were applied to the Road Accident Fund, negligent driving, right? But obviously it doesn't apply in terms of the fund, so we left really with some other form of negligence, let's put it that way. And I've taken that from a recent decision, or fairly recent decision, of the United Kingdom Supreme Court. That's their highest court. It's Paul and another versus Royal Wolverhampton NHS Trust. Now, what's important about Paul's case is that Paul's case, and quite a lengthy decision, but in my view, a very well written, certainly a very, very well researched decision, goes into the question of emotional shock and looks at all the different aspects of emotional shock, and in particular looks at why emotional shock should be limited and in what circumstances. And therefore, it is of interest when dealing with emotional shock cases because of its comprehensive treatment of the subject matter. As South Africans, we have to be careful of looking at Paul's case because there's certain ways in which Paul's case does not apply in South Africa. But by and large, it's quite a good guideline as to how our law will approach emotional shock. And in my view, it would be very helpful to refer to Paul's case when dealing with some of the higher level questions that arise around emotional shock. Paul's case now, just to get to the actual facts, so let's just demonstrate a little bit of this concept of emotional shock. For the medical or healthcare practitioners, bear with me. We're going to go through this a little bit, but it will relate back to that sub-regulation. So just bear with me. We'll go step by step, and then we'll bring it all together at the end. Paul's case related to 3 conjoined appeals. Each appeal related to a claim by an appellant for psychiatric illness caused by viewing a traumatic event which was caused by a respondent's negligence. In each case, the appellant witnessed or attended shortly after a death caused by the respondent's negligence. So there we go. We're looking at emotional shock because it's not an injury directly to the person, physical injury. It's an injury through witnessing a horrifying or traumatic event. Then let's have a look at one of the locus classici on this point in South Africa. There's not a lot of case law in South Africa on this. This goes back to 1972, very well-known decision. But just in summary, relevant for tonight's purposes, what happened is there were 2 minor children who were running across Stella Road in Durban, and a motor vehicle collided with the younger child who was 6 years old, called Werner. Werner died later that day of the injuries sustained by him in the collision. At the time of the collision, Dion, who was the older child, he was 11, was approximately 2 yards in front of Werner, and he just crossed the street and the vehicle did not collide with him. So there was no direct injury from the motor vehicle. According to the evidence, the vehicle collided with Werner approximately 1 yard behind Dion, and because he, so the court of quo found, was himself in danger owing to the way in which the driver drove the vehicle, and because he had to witness the fatal accident immediately behind him, Dion suffered a serious shock affecting his psyche and leading to an anxiety neurosis, which required medical treatment. So the important fact here, motor vehicle collision, motor vehicle accident, but the claimant himself does not suffer any contact with the motor vehicle. But as a result of the horrifying event of watching his brother run over and effectively killed by that motor vehicle, he suffers shock affecting his psyche and leading to anxiety neurosis, right? So there's a consequence. But can you claim? Dion was diagnosed with an anxiety neurosis which resulted from the psychiatric injury or emotional shock suffered by Dion at the time of the accident, as a result of both the fact that Dion had been in danger himself and feared for his own safety, and the fact that he had to witness the fatal collision with Werner immediately behind him, and the fear and feeling of guilt arising therefrom. So there's a complex matrix there of sequelae. Now, what's important? The court held that the brain and nervous system form part of the human body, and therefore a psychiatric injury constitutes a bodily injury within the meaning of that. There's a previous act. We didn't put that act in, but in the meaning of effectively the version of the Road Accident Fund that applied at that time. What's important? Brain and nervous system form part of the human body, and therefore a psychiatric injury constitutes a bodily injury. Then let's have a look at Hing and others. This was a case in which a number of tourists came to South Africa in Cape Town, and they were unfortunate for one of the ladies' birthday parties, and they were involved in an accident, and one of them was killed, and the others claimed made various claims. In Hing's case, Ward Bin says the following: the number of reported cases in point in South African jurisprudence on emotional shock is very small. The effect of the judgment in Bester was to treat psychiatric injury, provided it conformed to an identifiable psychiatric condition. That becomes important. Afrikaans herkenbare psychische letsel, as legally indistinguishable from any other form of bodily injury, its organic basis lying in the effect of the wrongdoer's conduct on the claimant's nervous or neurological system. That approach was reaffirmed in another famous case, Barnard versus Santam Bank, a 1998 Supreme Court of Appeal decision. What's important and something to sort of take away from it is that the old appellate division and then the SCA said that a psychiatric injury must conform to an identifiable psychiatric condition. Afrikaans herkenbare psychische letsel. And I can mention the word disorder. And there is the link now starting to emerge between the regulations and the law relating to emotional shock. So that's the first point, is the way where the regulation talks about disorder, in terms that's an identifiable condition in terms of DSM-5, and we will get Trevor to talk to us. He's more qualified than I am, but that he will comment on that. But you can take that provisionally for the moment. And then just lastly, in Hing's case, I do not think that the trial judge can be faulted for deciding that the content of Dr. George's report did not establish that the first appellant had suffered an identified psychiatric injury. So the courts are, in terms of emotional shock, are on the lookout for an identified psychiatric injury. In other words, a disorder is the way the courts look at it. That the judge was justified in holding that manifesting some symptoms of post-traumatic stress syndrome did not equate to a diagnosis that the appellant was suffering from the disorder itself. In other words, the court was not satisfied because there wasn't a disorder. So that the question of psychiatric injury was now not satisfied. Now, it must be emphasized that these requirements relate to emotional shock cases, i.e., where the claim is made by an individual making a claim for psychiatric injury caused by witnessing the death or other horrifying event of a close relative or possibly another person as a result of earlier clinical or other negligence. Now let's have a look at regulation. That's by way of background. There are just 2 points I want to make just to recap and to orientate ourselves. So the first point is, what we've looked at so far is emotional shock. However, within the context of emotional shock, there's a line of authority and a generally sort of accepted approach by the courts that what one is looking for is a disorder. Those 2 points are important in unpacking 3.1b, 3c. And this is why. Okay. 3.1b, 3c says, in part, the relevant part, resulted in severe long-term mental or severe long-term behavioral disturbance or disorder. So we can look at each of those words becomes very important. Severe, Herman has already touched on. We will look at that in detail as to what Judge Rogers says about severe in a moment. Long-term, normally that's not such a problem, okay? That's something for the experts to advise on, and it's the sort of thing that you can get to grips with. Mental, what does that mean? Then severe long-term behavioral disturbance or disorder. So let's have a look at that. Those consequences will relate to pecuniary advantage and or pain and suffering. In other words, when one looks at 31B3C, there are in the case law, there are two subcategories that the case law refers to, and that is pecuniary advantage or pain and suffering. So it could affect work performance, or it could be that person experiences certain pain and suffering, loss of amenities of life, etc. We are now talking about your outcome diagnoses. All right. Now, there is a principle in South African law that every word in an act or in a regulation must be interpreted. And if one looks at the provisions that I've referred to, look at those words, behavioral disturbance or disorder. Now, we know what the courts mean by disorder when they're talking about emotional shock, and that must surely give us some clear guidance as to what they mean by disorder in the narrative test. In other words, an identifiable psychiatric condition. Trevor can help us with the exact fine-tuning that. But that is, our courts are well familiar with that concept. The problem comes in when we're talking about behavioral disturbance. What does that mean? Do we get any assistance from the regulations? Do we get any assistance from the law? And the answer is actually not. The other point to note here, which relates to that, is serious and severe should be serious or severe to the claimant. So when you're looking at serious doesn't occur in this subsection, but as we saw in Herman's presentation, serious applies to I think both A and B off the top of my head. And that needs to be assessed in connection with that particular claimant. Now, one needs to look at the intention of the section when you interpret it. And remember, we're dealing with the narrative test. Remember that we are dealing with the particular circumstances of that particular claimant. And so what is the narrative test trying to do? If we sort of zoom out, where are we? What are we trying to ascertain here? And that is whether the claim is serious enough to qualify for general damages. Now, Herman mentioned something which arises in their article, and he referred to that expression, life-changing. And if one has a look at that 30% yardstick, which, as I said earlier in my earlier address, is quite a high hurdle, I would endorse that particular approach. That question of life-changing sits well with the 30% yardstick. I also want to make this point. In respect of emotional shock, the courts are concerned with the specter of limitless liability. Okay, what do we mean by that? When the courts look at emotional shock, and in other words, why am I relating a proper interpretation of Regulation 3 sub C to emotional shock? It's because emotional shock has been interpreted narrowly as to include disorder only, psychiatric disorder, a lesion. We saw the definitions. The regulation includes disturbance, and disturbance may be something, potentially is something less than a disorder. In other words, the field of assessment is potentially broader than the field of assessment for emotional shock. Now, when the courts deal with emotional shock, and it's my view, and we're going to bring this into practice, so don't worry if you feel, well, this is a bit abstract. We'll bring this into practical advice towards the end, but it's important to understand the context, even for the medical people. When you talk about the specter of limitless liability, in other words, why the courts are conservative in what they will award for emotional shock. You'll see that in Hing, the court referred to the consideration that the recovery of compensation in delictual damages, and that basically includes motor vehicle accidents, for psychiatric injury has proven a contentious subject internationally, particularly in the context of emotional shock. Because of the crucial role of policy considerations, especially due to concerns about potentially limitless liability, expressed as the specter of loss, there's a famous case, it's actually an American case where the judge talked about a similar subject, the possibility of loss in an indeterminate amount for an indeterminate time to an indeterminate class. So what am I saying here? I'm saying this, that the courts, when they deal with emotional shock, are nervous about casting the net too wide, because it would be too easy. We've already heard from Herman that it's difficult to assess some of these aspects related to the psychological aspect. Now imagine every single person who has had something, one of their relatives injured in a motor vehicle accident can simply claim. You can see from a policy perspective, from the courts managing limitless liability, that can be concerning. And for that reason, the courts are strict on their interpretation when it comes to emotional shock. The next point that I make is that these considerations do not apply in the context of the narrative test. In other words, the concerns about loss in an indeterminate amount for an indeterminate time to an indeterminate class do not apply to the narrative test. I've talked about the intention of the narrative test should be considered. Now, we've already heard what the intention of the narrative test is. We've already heard that the narrative test is very closely tied to the individual circumstances of that person. And it is an assessment of that person's circumstances that we're dealing with. So if we look at, we can note that serious and severe obviously in that subsection should be serious or severe to the claimant. In Australia, the courts dealing with the narrative test ask the following question. Now, remember I said to you a few minutes ago that the narrative test originated in Australia. This is case law relating to the Act of Parliament and to the narrative test in particular. So this is a sort of rule of thumb approach that the Australian courts take, and I'm going to just comment on that. Let's go through the test first. Can the injury, when judged by comparison to other cases in the range of possible impairments or losses, be fairly described at least as very considerable and certainly more than significant or marked? And there's the case Humphreys and another, it's a Victorian report decision, Victorian case. I find Herman's approach and that article, the South African Medical Journal approach, this article as to a significant life-changing event fits squarely with this test. They don't talk about life-changing. Personally, I like that expression. It fits well with what we're trying to do with the narrative test. And to my mind, if one were to apply that test to the general Australian thinking here, you would start getting close to what I think the correct approach should be. Because significant life-changing is more than just significant. It adds an additional criterion, as Herman pointed out. Okay, so let me just, before I get to this slide, I just want to recap. So where we are now is that when one looks at emotional shock, the courts have defined it very narrowly as a disorder. Regulation 3(1)(b)(3)(c) potentially opens up a finding of, in accordance with the narrative test, for something less than a disorder by referring to behavioral disturbance. Trevor will address us on practically what the approach is, but I would invite you to consider whether that is not in fact the case, that the narrative test opens the assessment more broadly than what it does for emotional shock. And then I just want you to have a look at this definition of serious injury. which came up. This I believe is Rogers's judgment in JH. Certain injuries are, in terms of Regulation 31B1, expressed as serious injuries. The applicant's case is not excluded by any of these. In terms of Regulation 31B2, an injury is serious if it has resulted in a 30% or more impairment of the whole person, WPI, as provided in the AMA guides. The applicant's case also in that case did not rise to that threshold. So wasn't knocked by the non-serious, but didn't comply with the AMA guides. This leaves the so-called narrative test, of which A to C are of potential relevance, namely, whether the injuries resulted in a serious long-term impairment or loss of a body function, or resulted in severe long-term mental or severe long-term behavioral disturbance or disorder. And then the words serious and severe in these items are not defined. They connote a degree of impairment or disturbance of disorder which cannot be fixed by quantitative measure. Remember what Herman went through. The assessment requires a value judgment, though one to be performed on the basis of a correct interpretation of the words in the narrative test. Dictionary definitions of serious in a context appropriate to the narrative test include having important or dangerous consequences, critical, approaching the critical or dangerous, while definitions of severe include inflicting great pain or distress of a serious or considerable degree or extent, grave, unsparing, pressing hard, hard to endure. In ordinary parlance, the word severe connotes to my mind a greater intensity than serious. So C then imports a higher standard than A and B. This contrast is reflected in the definitions in the Shorter English Oxford Dictionary. Serious, important, grave, having potentially important, especially undesired consequences, giving rise for concern of significant degree or amount. Severe, disagreeably intense, unpleasantly extreme, causing hardship, pain, or suffering by its degree of extremity. Then the judge goes on to say, since the lawmaker chose to use serious in items A and B and severe in C, it is reasonable to infer that some difference of degree was intended. The distinction may have been drawn because impairment or loss of body functions was regarded as more tangible than mental or behavioral disturbances and disorders. Just that last sentence, I just want to unpack that. In other words, what the judge is saying is that the reason, firstly, A and B use the word serious. That yardstick is not as high as severe, which is used in C. And then he contemplates, without finding, that the distinction might be because impairment or loss of body functions, in other words, A and B, are more tangible. In other words, it's easier to assess, and we've heard Herman say, it's quite correct, than mental or behavioral disturbances and disorders, and therefore the bar is set higher within the language of the sub-regulation. And what does that mean? It's a safety measure, in my view, built into that sub-regulation. And what's it a safety measure against? It's a safety measure against the specter of limitless liability. In other words, within the regulations themselves, there is already a safety check to ensure that the subsection is not easily abused. And I would then suggest that when one looks at the language of the sub-regulation, look at the intention of the narrative test, and bear in mind that there's a safety measure built into that very section. That is why you can safely, which I would say to the courts, can safely expand and relax that strict definition which they've applied in terms of emotional shock. In other words, you do not need a psychiatric disorder. You can settle for something less. And that is the behavioral disturbance, which is referred to in sub-regulation 3C. Goes on, I'm just going to finish these just to support what I've just said. The purpose of limiting non-pecuniary damages to cases of serious injury must have been to introduce a significant limitation on the RAF's liability for general damages. So even with serious, it's significant. In context, serious and severe should not be regarded as not trivial, since trivial cases are unlikely in the past to have placed a significant burden on the public purse. Remember, we looked at the Satchwell Commission. The whole purpose of the narrative test is to get away from all these little trivial cases, trivial claims for general damages. That is built into the language of the regulations. On a continuum from trivial at one extreme to catastrophic at the other, descriptors which come to mind are mild, moderate, serious, and severe. That which is serious must be more intense than moderate, and that which is severe must be more intense than serious. Then 20, seriousness and severity must take into account the victim's particular circumstances. While some impairments, disturbances, or disorders might be serious or severe for whomsoever suffers them, others might only obtain these thresholds because of the victim's chosen profession or pursuits. For example, well-known ballerina's toe or violinist's finger. Then he concludes, in the case of items A and C, the impairment, disturbance, or disorder must be long-term. That did not present a difficulty in that case. It very seldom does. Normally, the long-term is not a problem. 22. The manner in which pain is accommodated in the narrative test is not clear. Item A requires an impairment or loss of a body function. Pain is not per se the impairment or loss of a body function. Depending on its intensity, pain may give rise to an impairment of a body function. The ability to concentrate, for example, could aptly be described as a body function, a function of the brain, and might be impaired by pain. I rather doubt whether pain per se could be described as a mental disturbance or mental disorder, though again it might, depending on its intensity, cause a mental or behavioral disturbance or disorder, for example, depression. Right, so just to conclude this aspect, for the narrative test, consider whether a disorder is present. This is, I'll make some practical comments now against that background. One, you need to consider whether a disorder is present. If a disorder is present, it's much simpler because the narrative test then you're into the narrative test, right? You just have to consider the effect on the person, and if there's a disorder, you're in on C. If not, consider whether the disturbance is close to qualifying as a disorder. I'm going to let Trevor touch on that as well. But if you don't have a disorder, but you've got to remember the one case, there wasn't quite PTSD, but it was close. That's a strong practical signifier that you're in the narrative test because you're close to a disorder. And then your counsel can argue exactly what I'm arguing here and then tie it into the facts. Then take into account the plaintiff's particular circumstances, again, to develop this point, to build a case. Remember, you need to make an argument in your narrative test. Consider whether the consequences will relate to pecuniary advantage and or pain and suffering. All right, that's just a way of practically looking at it and building your case again. And then we get to the Australian test. Consider whether the injury, when judged by comparison to other cases in the range of possible impairments or losses, can fairly be described at least as very considerable and certainly more than significant or marked. I would invite you to apply Herman's test in that article as serious, life-changing. I personally very much like that test. Okay, and then Trevor, I think with that, let me just hand that over to you, and if you could make some comments on those thoughts, please.
Ian, thanks very much. I don't know if I can be heard. Thank you very much for providing a very comprehensive background to what I'm going to say.
Trevor, sorry, just so that you know, we can hear you and see you clearly, so don't feel that you're out on a limb there. We can hear you and see you.
I'm not sure if it's good news for everybody that you can see me. I apologize for that. But,
no, not at all.
I come from a particular perspective which is not very favorably viewed by many people. And that is why the question I ask myself is, why is the victim or the third party who has suffered psychological harm as a result of a road traffic crash being held to a higher standard, and in fact being forced to submit to what could be seen as an unconstitutional requirement. And I think that you've touched on many, many things that, for me, help to understand what is going on. And I'll come to the way that I try to deal with this practically within the constraints of what I can professionally, ethically, and reasonably account and justify. But I must have put up a disclaimer that I worked for 10 years in a neurosurgery rehabilitation unit. And as a result, I suppose a lot of my sentiment lies with the victim of head injury and the victim's family of head injury. I think, to move on a little bit, one of the things that perhaps is an open door is the JH versus the HPCSA, where, as I said, the person who has suffered a psychological injury has to suffer a severe injury, a higher standard of severity than the person who suffered a physical injury. And I think that that opens up an entire can of worms about the practitioner, from the court down to perhaps the legal and healthcare providers at entry level, considering that psychological harm and claims for psychological compensation for psychological harm are things that don't really belong. It's just because you have a couple of little problems and you don't sleep as well at night and that kind of stuff, that's really not important, because remember, other people have lost function, physical function. They got disfiguring, scarring. How terrible must that be? The fact that you have psychological harm, got to hold you to a higher standard. Coupled to that is the fact that in most instances, in order to qualify, and Ian has touched on this, in order to qualify for the awarding of damages, you have to suffer a psychiatric disorder, a psychiatric injury. And I think that in terms of each word in the legislation being interpreted and assessed on its own, this gives a very good example of where there's an inconsistency or loss in translation, where a psychological injury or a psychiatric injury is not the same as a psychische besering of a psychische entiteit. So you're talking about a psychiatric, a diagnostic criteria on the one hand, a diagnostic entity, versus a psychological condition. And a psychological condition, almost by definition, is not a disorder. It's a disturbance of ability to live. So what do we do when we start looking at psychische letsels, psychiatric conditions? The fact that we have to look at confirming that the person has suffered a psychiatric disorder from the basis of, if we want to motivate that this person qualifies for general damages, then in a way we've got to prove that that person has suffered a psychiatric disorder or suffers a psychiatric disorder. Whereas if it's a disturbance, what does it do to the dignity of the person to have to accept a psychiatric disorder, a psychiatric diagnosis, merely in terms to qualify for claim? If we go back a little further, one of the things that struck me from the outset, having a look at emotional shock, emotional harm, and many of the cases and the principles that Ian spoke to dealt with the witness to something. So I saw my brother run over. I saw, I'm a school teacher, I see children dying in the school bus. I'm not directly impacted. I'm not a direct victim. I'm not in the accident itself. Vanessa asked the question, what happens if you're in the accident? You don't suffer a physical injury, but you're profoundly traumatized. It takes some, the emergency personnel hours to extricate you from the vehicle. The other passengers in the vehicle have suffered terrible injuries, perhaps fatal injuries. you are in a position where you are powerless, that results in at least a psychological disturbance. Is that the same as someone standing on a street corner and seeing somebody being knocked over? And I think that a lot of the basis for the legislation and regulations is that the person standing on the street corner seeing an accident is taken as the benchmark, as the criterion, rather than the person who suffers an injury, but a non-physical injury, unless the court decides to determine that a psychological injury is an injury to the brain and therefore it is a bodily injury, which I think is really stretching. The bottom line for this, I think, is that in many instances, psychologists, and I'm speaking for myself particularly, I'd sit in a position where I have to ask myself, firstly, does this person present an account that allows me to say that he or she meets the diagnostic criteria for a psychiatric disorder? If so, that is easy. It is met. The person has a psychiatric diagnosis. Everyone is happy. Perhaps not the third party, but everybody else is. If, however, the person presents, and many of you will have read in my colleagues' reports and in my report, that they present, the third party presents with symptoms of a disorder, but not sufficient symptoms to warrant making of the diagnosis. And that cannot then say, well, we don't pursue that any further, because by saying that, it discounts the severity, the seriousness, the impact on that person and his or her particular circumstances. And that is where the extent of the narrative test for me becomes very, very important. In terms of the structure of the test, what is critical is to identify that the accident, the events around the accident constitute a life-changing, a watershed event, that before the accident, these symptoms did not exist, or did not exist to the extent that they impacted the person's quality of life or ability to enjoy amenities of life. But after the accident, regardless of whether he or she suffered physical injuries or has physical lesions, the quality of life, the ability to enjoy those amenities of life have been materially impacted. So the detail with which I have to define pre and accident descriptions of what the person, how the person is living, and what the effect of the accident is on that person. What is important is that it also bears almost emphasis to say that in the eyes or the mind of the third party, the person is attributing that significant change to the accident and its sequelae. Attributing that significant change is reasonable. You can understand that being involved in this accident and then presenting in that particular way is reasonable. And therefore, the person has a reasonable belief system that my quality of life has been changed because of the accident. So a lot of detail that needs to go into that. Where I can, I describe the psychological, the psychiatric symptoms, make it very clear where the person meets diagnostic criteria, where the person doesn't meet psychiatric criteria or diagnostic criteria. But I then also make it very clear that even if the diagnostic criteria are not met, the impact on the person's quality of life is significant to the extent that there has been a watershed change, a change in quality of life. One of the things that concerns me, and I think Ian has touched on it, and it's a consequence of Frankensteinian regulations, if I can coin that term, is that I think a lot of the terminology within the regulations and the way of thinking stem from not having a coherent concept of where the legislation and regulations need to be. So things are kind of patched in, and because of that, we sometimes deal with odd concepts, which as a result make it possible to exploit the question around, is a psychological condition something that is tangible, like a physical condition? is it a lesion or is it something else? And one of the important questions, elephant in the room, is how many people get assessed in terms of the psychological condition, opening up the gate to malingering or pursuit of undeserved compensation, almost in the eyes of some people that, well, if you complain of psychological harm, you don't have a lesion, so you've got to be trying to make money out of this. You might gather from what I've been saying that I'm rather emotionally charged up, quite intense about this, because I think that, especially within the context of people suffering head injuries, but more so in the case of people who suffer psychological sequelae of motor vehicle accidents, in terms of the RAF work we're dealing with now, is that the psychological harm is almost an add-on to the physical harm. And if we go back really to the beginning, the AMA guides, I think, without sounding facetious, those are great for people with orthopedic injuries, but I'm not sure that they really fulfill the requirements elsewhere. In terms, just one of the ways of, one of the things that I could do to demonstrate that is to say that if we look at assessing psychological harm at this stage, if we say there's a psychological disturbance, we need to be able to quantify that in terms of the regulations. And the regulations specify that you have to use psychiatric rating scales. So it's a kind of a tautology, there's a kind of paradox that I don't have a psychiatric illness, but to justify why I don't have a psychiatric illness, I've got to use a psychiatric questionnaire to show that I in fact have psychological harm, but not a psychiatric illness, which seems kind of absurd. And it all relates, I believe, ultimately to the fact that psychological functioning and emotions are not tangible. They are not tangible, and because of that, our courts have difficulty exercising judgment in assessing the particular circumstances of the third party. The court applying its mind to the particular circumstances, the facts of the case, and having a look at what it would be reasonable. And it is therefore incumbent for me as a clinical and neuropsychologist, at least, and for colleagues across other disciplines as well, to provide as much logical, reasonable information for the court to consider, apart from the regulations, the prescriptions, and the ambiguity of the language within which they're written.
Okay, Trevor, thank you very much. We are running short of time, and there's a question that I want to get to. Any final remarks that you'd like to make? Thank you very much for that input.
Ian, just thanks for the opportunity. I will now kick my soapbox back under the desk.
No, thank you very much. Very helpful. And thank you very much for your help in preparing the presentation as well. Your time is much appreciated, Trevor, and very nice chatting to you again through the whole experience. All right, and Trevor, please stick around, because we've got a question that you may want to make an input on. Herman, you might want to come in on this as well. Cobus, I'll tell you what I'm going to do. I'm going to unmute you, and then, or I can ask you to unmute. Please will you unmute yourself and ask the question? Herman, I've seen your hand raised, but we'll let Cobus ask, and then you can, whatever your contribution you want to make, you can work into your response. Cobus, so you're able to do that?
I think I'm on mute now. Thanks, Ian.
Yes, I can hear you, Cobus. How are you?
Fine, and you?
Very well, thank you. Please go ahead and ask your question, Cobus.
Thank you so much, Ian, and thanks, Dr. Eder and everybody. It's really a great evening. I'm involved in the RAV4 business now for 15 years or almost, and we've got a problem with head injuries, for severe traumatic brain injuries or significant head injuries. Different courts, different judges, different attorneys pressurize us to not give a 5.1. If I've got a proven head traumatic brain injury with physical consequences, cognitive deficits proven, chronic headaches, post-traumatic epilepsy, whatever the case may be. They don't accept the 5.1, and I don't understand why. They want us to give a 5.3, even push us and force us to change the RAV4 and take out the 5.1, give a 5.3. And I know how grey area and Dr. Edeling has actually explained a lot of that when discussing the narrative test, but it's such an irritating ongoing thing. And I also, a lot of them say, listen, and I know it, according to the AMA guidelines, if you start with table 13.5 on the post-traumatic or loss of awareness and consciousness and go to 13.10, you can't add up them. You must choose one of them. So I've actually got two questions. My main concern or problem is the 5.1, because I'm 100% sure that even though with the flaws and the problems with the 5.1, that a physical consequence from a significant or severe head injury that doesn't reach 30% falls under 5.1. I mean, obviously, if there are PTSD proven by a clinical or neuropsychologist and or major depressive disorder and so on, you can give both. But I really get a lot of pressure from certain regional high courts and the attorneys and certain judges that for some reason believe that anything to do with the head injury falls under 5.3. That's my main concern and my big question here.
Thank you, Herman. I think you can come in here.
Yes, thank you, Ian and Trevor, and thank you very much for that question, Cobus. Cobus, I totally agree with you. I am a neurosurgeon and I deal principally with traumatic brain injuries. And I know, because I've seen it, I've cut it, I've operated on it, I've taken things out of it and put things into it, the brain is a part of the body. So 5.1 says an impairment or loss of a part of the body, and the brain is a part of the body. Now, when you have a brain injury, that brain is damaged, just like a lung injury or a liver injury or a musculoskeletal injury. And if that physical injury to the brain has resulted in an impairment of brain function, whether it's cognitive, executive, neurophysical, emotional, mood, self-control, behavioral, those are all functions of the brain. And when the damage to the brain, physical damage, has resulted in consequences of a cerebral neurological nature, then obviously and rationally it should form part of 5.1. And when I write RAF1, RAF4 reports, I add a little text in above that 5.1 on the form, where I say serious long-term impairment of brain function, indicating that the brain is the body part, as opposed to serious long-term impairment of back function or leg function or liver function. Now, I've also come across exactly the same problem that you're talking about. This was a case I did for lawyers in Port Elizabeth, where whoever was clever enough to say that I was wrong said that if it's a brain thing, it has to be in 5.3. And it didn't matter how much I explained or discussed, they would only accept it if I did 5.3. Now, part of the problem, and I spoke about the poor and the vague, imprecise wording of the narrative test as it appears in the regulation. It has to do with the word mental, because mental has got two completely different contexts. The one is, if you think in terms of physical brain injury and brain neurological function, when there is a pathology of the brain, whether it's a tumor or a stroke or an injury, and it damages the brain, then the mental function of the brain can be hampered, like cognition, executive function, memory, concentration, etc. So that is a mental impairment resulting from physical damage to the brain, irrespective of the nature of the damage. But completely outside of that, as if it's a different animal, is the thing of mental disorders. And those are psychiatric diagnoses. Those diagnoses which are housed in the DSM-5 those are referred to as mental disorders. So bipolar mood disorder or ADHD, all of those are in the absence of a physical injury to the brain. It is as though those are disorders of the mind, but they are called mental. And that to me is part of the problem of medical opinions being interpreted by lawyers. Because a lawyer might be thinking in terms of the one meaning of mental, and the doctor might have been thinking in terms of the other meaning of mental. And this is part of the reason that we wrote that article in the SANJ, was to try and be clear and specific. Now, because of this, one can argue that if you have a cognitive, executive, and behavioral problem resulting from a brain injury, you qualify under 5.1 and under 5.3, because you've got a disturbance of mental function from a loss of brain function, that's 5.1, and you've got a severe long-term behavioral disorder, that's 5.3. So, in fact, what I did in that case where I was challenged, I just said, okay, well, it's both, and I explained why it is both. And in many cases now, in order to avoid that stupid argument, in my view, I just mark both of them, 5.1 and 5.3. Except I can't mark 5.3 if the disturbance or disorder is not bad enough to be called severe. So one can only mark 5.3 if the behavioral disturbance or disorder is severe. So, Kobus, I'm sorry, it is a real problem, and the problem is in the wording. And then, Ian, I want to take issue with what you said, not because I think you're wrong, because I think your detailed and careful legal and case law related definition and interpretation is 100% correct. But strict application of that from words that were just pasted in there as a copy and paste without any real thought leads, as Trevor explained very well, to serious practical problems in terms of human rights and constitutional values. So I don't think that it is, let me call it morally right, to place too much reliance on the words. And remember, it wasn't the legislature that decided that, it was the Minister of Transport. And the Minister of Transport is not a medical expert. Those words were in the regulation of the Minister of Transport. They are poor words. It's a poor choice of words. It is why we had to write that article. And that article, having stood the test of time, if you just forget for a moment about the judicial interpretation of severe and serious and mental and disorder and disturbance and all of that. But if you think of it in the way that Trevor said, and I think Trevor is right, that if the psychologist determines that whether it's PTSD or whether it's chronic anxiety disorder as a result of the impairments and my inability to feed my family, or it's chronic depression associated with the chronic pain and disability and loss of my job, loss of status, and loss of my ability to conduct my activities of daily living, I have a serious disorder of psychological function. And that disorder is so serious as on its own right to constitute a significant life-changing event. I think that is what is important. And one can go to the words significant life-changing sequelae rather than the words severe disturbance and disorder. And I don't actually believe, Ian, that in choosing those words, the Minister of Transport had in mind that disorder has to be something defined in the DSM-5.
Herman, can I just respond to that? Just firstly, look, you know, I suppose you come from different perspectives and you see things slightly differently. When you get to court and you argue it, obviously the words really do matter. But having said that, and I must say that is you know, that's the way that they're interpreted and the power that flows from those words can't be underestimated. But having said that, I actually am in agreement with yourself and with Trevor that if one, and what I'm suggesting is that the words, when you're using it in terms of the narrative test, should be interpreted less stringently than requiring a disorder, because you're not looking at emotional shock. You don't have the same pressures on the system. In other words, you don't have the problem of limitless liability, and therefore the courts can take a more relaxed interpretation of those words and open it up to more than simply a disorder as diagnosed in terms of DSM-5, but can look at something less. And then, of course, it depends on your interpretation. And I actually happen to think that the interpretation that's been suggested about a serious life-changing condition, I think is about right. So I understand that let me say that I think that your disagreement is more with the legal system than with myself, and maybe I'm a poor representative of that system. But my view is, in summary, is that in my view, the narrative test should allow for a broader range of conditions than simply a DSM-5 strict classification of a disorder. So that's for the reasons I set out.
Thank you very much, Ian. And by the way, I'm not criticizing you. What I'm saying is, because the words are so vague and so poorly chosen, in practice, I don't think one should feel oneself unduly bound by poorly chosen words. But when you come to the absolute interpretation and legal argument, of course you're right.
Yeah.
And that's not what I'm criticizing. I'm saying, let's try and go with the intention of the act rather than the poorly chosen words of the Minister of Transport in 2008.
No, look, I completely agree with that. And also Trevor's point about properly motivating, I think must also be underlined. All right, well, thank you to everybody. I'd actually hoped that we would have a bit longer for questions and answers, but I think we've dealt with some very, very good questions from people. I thank everybody for attending and for staying. I see our numbers have remained constant. Trevor, Herman, Magda, thank you so much. Behind the scenes, Zita's done a lot of work, a lot of hard work, and she's been taking care of people, and she's done a phenomenal job. And I just really want to thank Zita very much for all of her efforts. She refuses to participate on the public part, but she's working very hard behind the scenes, and her efforts are very much appreciated. And I'm sure everybody has received very good support from her. There are just a couple of closing remarks that I would like to make. Let me just call them all up and just go through them. I'll be a minute or two, but of a sort of housekeeping nature. I beg your pardon. All right, there we go. So firstly, can I just call on everybody, please join the narrative test group. I will be putting material on that group, including links to the relevant articles where they are available. We'll be putting up references to the authorities that have been talked to. So there's quite a lot that will come up on the narrative test group over the next few days. And then any developments that come up, we will put on that narrative test group as well. We will also create a section on the website. Just give us a day or two to get that section up and running, and we will then alert you via the WhatsApp channel or the WhatsApp group that section of the website is available to paid subscribers to this webinar. For the medical practitioners that are looking for CPD points, the assessments will be available probably by tomorrow evening. They'll be up on the South African Medico Legal Reports website, and those assessments can then be conducted on site. And this event is worth 3 CPD ethics points, which is accredited with the South African Medical Association. Just insofar as the booklets are concerned, most of you should have received your booklets. There are 1 or 2 errors in the booklets. I apologize for that, entirely my fault. If I can just by partial excuse, is that we've been under a lot of pressure. We're busy in different domains. What's contained in this booklet will be part of the South African Medico Legal Reports Quantum Guidelines, which we'll be releasing fairly soon, and that is going to be, it's a very exciting work that we're working on. So this aspect of the quantum guidelines is really something that you've been given as part of the webinar, And so we hadn't quite finished with all the checking and that sort of thing with the booklet, with that particular chapter of the quantum guidelines, but you've received it basically as part of the webinar. And please just overlook the little typos, etc. We will fix them in a subsequent edition. For those that haven't that registered after, I think it was Thursday, your materials will be posted this week. So you'll get your guidelines during the week, and all the other online materials will be there. We will be putting up I've said mediation program. That was a slip. It should be a webinar program for 2025. The reason why I said mediation program, I think, is because we probably the next webinar that we hold will be on mediation for non-mediators. So if you're not a qualified mediator, but you want to know about mediation, we are seriously considering that as our next webinar. But we will arrive at a conclusion about that in the next day or two, and we will let people know. And then this particular webinar will be available on demand. We've had quite a few queries about that. This will go up again. We need to download it and edit it. So it'll be on demand, probably available from about the middle of the week. Being realistic, probably around about Wednesday, this will be available on demand. Those are the housekeeping matters. I think I've covered everything. Just remains for me to thank everybody for your time, everybody for your contribution, and I found the evening very, very interesting. And I always find that I learn a lot more than I teach when I do an exercise like this. So thank you to everybody. Have a good evening and have a good week. Thank you.
Thank you, Ian. Cheers.
Cheers then. Bye-bye. Bye-bye, everybody.